I request Advocate Bindu Srinath to read the preamble of the Constitution.
As an ordinary citizen of the world's largest democracy, standing here with the photographs of the father of our nation, Mahatma Gandhi, and the master draftsman, Dr. B.R. Ambedkar, behind me, and the distinguished dignitaries on my left, the members of Calicut Bar and bench before me, the members of the Fourth Estate as well, I should say I'm absolutely honored and humbled to recite the preamble in obeisance to the supremacy of the Constitution prior to commencing today's function. The preamble reads, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." Thank you. May each word of the preamble be engraved in our conscience and guide us to become a responsible citizen. Thank you.
Thank you, Bindu. Now, today's topic is the challenges faced by the Indian judiciary. You will not be astonished if I would say that judiciary is a ship that is sailing in rough weather. There is interference in administration of justice from every nook and corner. Great sea captains are made in rough waters and deep seas. Our distinguished chief guest and speaker of the day, senior advocate Mr. Prashant Bhushan, is the most suitable captain to guide us in this rough weather. He will be addressing us on the challenges faced by the Indian judiciary. Constitution of India is his holy book. He is a crusader for human rights, judicial reforms, and social activists. Law was not his initial choice. In 1977, Mr. Bhushan joined IIT Madras to study mechanical engineering, but quit after the first semester. He returned to his hometown Allahabad, completed his graduation, and joined for a law degree. Before completing his law degree, he went to Princeton University at New Jersey, America, to pursue studies in philosophy and physics. However, after 1.5 years, he returned back to India and completed his law degree. He started his practice in 1983 in the Supreme Court and Delhi High Court. He has authored few books. When he was a student, he authored The Case That Shook India. This is a book related to the election case of Indira Gandhi in 1974. The other book, which was authored by Advocate Prashant Bhushan, was Selling of a Nation. It was published in 1990 on the Bofors scandal. Mr. Bhushan is known for his pro bono works, especially in matters that involve public interest. We know the recent contempt proceedings against Mr. Bhushan, where he refused to tender apology and which culminated in payment of just ₹1. I quote in his own words the statement that he made before the Supreme Court. Quote, "If I retract a statement before this court that I otherwise believe to be true, or offer an insincere apology that in my eyes would amount to the contempt of my conscience and an institution that I hold in highest esteem," unquote. I'm sure these statements will be the subject in future in law colleges. With this, I request Advocate K. Srikanth, Secretary of Calicut Bar Association, for welcoming.
Respected guest of the day, Advocate Prashant Bhushan sir, Honorable District Judge Sri Krishna Kumar sir, President of the Bar Association, Sajjiyamma sir, Honorable Vigilance Judge Madhu sir, and the Government Pleader A.K. Jayaprakash sir, Jayagumar sir, and the judges who are present here, the senior members of the bar, media persons, advocate clerks, and my dear colleagues. Calicut Bar Association is making a history today by starting a lecture series on the subject, the challenges faced by Indian judiciary. The respected senior lawyer of the Supreme Court, Advocate Prashant Bhushan sir is delivering the inaugural speech on the subject today. We are expecting eminent personalities from different walks of the life from all over the country to participate and speak on this subject. Dr. Shashi Tharoor MP, Sri Ravishankar Prasad, former Union Minister for Law, retired Justice K. Chandra, are expected to join with us to debate in this subject. On behalf of the Calicut Bar Association and all the persons who are gathered here, I extend warm welcome to our chief guest, Sri Prashant Bhushan sir. Our Honorable District Judge, Sri Krishnamar sir, is a part of all our activities, and I welcome you, sir, also. We have Madhu sir, Honorable Vigilance Court. Judge, I welcome you, sir. We have also Sri K.N. Jagumar sir, the Principal Government Pleader and Public Prosecutor of the district. I welcome you, sir. And once again, I welcome all the judicial officers, advocates, and members of the journalist community and well-wishers who are present here. Thank you.
Thank you, Secretary. Now I request Advocate M.S. Saji, President of Calicut Bar Association, to deliver the presidential address.
Distinguished guest of the day, Prashant Bhushan sir, Honorable Principal District Judge Krishnamar sir, Honorable District Judge Sri Madhusudanan, Secretary, the judicial officers who are present here, senior members of the bar, my colleagues, and all media persons, and all well-wishers. As our Secretary has stated, today is an important day in the history of our bar because we are starting a debate on a much sensational and relevant topic in the present scenario. The challenges faced by Indian judiciary. We will be exploring its every aspect by the most eminent person who is competent to speak in this subject, none other than Sri Prashant Bhushan. When talking about Prashant Bhushan sir, I do just remember I have read as at the time of emergency, his father, former Union Law Minister Shanti Bhushan sir and Sri L.K. Advani and also Sri Moraji Desai was traveling all around Kerala to speak and about the emergency and against the emergency and how our fundamental rights were arrested. At that time, Moraji Desai was translated by Mr. K.T. Thomas, at that the retired Supreme Court judge, and he was a young lawyer. And Sri Shanti Bhushan sir and Sri L.K. Advani was translated none other than by Sri Manjeri Sundaraj, who was a young, very young lawyer at our fraternity. So I think history is mingling here again in the form of Sri Prashant Bhushan sir, whose father has spoke and fought a lot, especially while he was the Union Law Ministry here. There were so many aspects are there regarding the challenges and the declining of the judiciary, but no one is there to speak about that because the swords of contempt of court 124A, which is about to be scrapped, are our head. Eminent persons have faced with the contempt of proceedings like M.S. Namboodiripad, V.R. Krishnaiyer sir, Arundhati Roy, and ever so many social activities, but no such proceedings could stop them, but made their voices more powerful and made their slogans more echoing. So such kind of acts are not sufficient to blanket the person who has resistance by nature and naturally. So I think this is very important, and we know so many other things which will be explained by Prashant Bhushan sir. The most funny thing is about the appointment of judges in the higher courts. I think law of inheritance is made applicable there. But no one is ready to speak there. My son is a judge, my grandson is a judge, my nephew will be the judge, and my coming grandson will be the judge. Such sort of situation has come. It's very deplorable. the thing is that the qualified persons who deserves, who coming from the downtrodden situations will be kept away from the judiciary. So the judgment will be also go against the humanity. So no one is there. The recent example is the scrapping of 99th Amendment of the Indian Constitution. And an amendment is appointment of NGSC. NGS, National Judicial Appointment Commission, was scrapped unanimously by the Supreme Court, even by the judges who is making voices for the protection of Constitution and fundamental rights. So, and we can also see that the judiciary is gradually getting subordinate to the political executive also. It's a fact. Writing pre-retirement judgments for the post-retirement appointments is another case. Writing pre-retirement judgments for the post-retirement appointment is also a case. Most of the judges from the Supreme Court, High Court are positioned in various aspects which is equivalent or more equivalent than the position they were holding. It's all facts. But no one is there to discuss about. But Calicut Bar Association has decided to discuss about whatever be to happen. Because we the people of India, as a democratic people, as read by the preamble, we have all right even to discuss and even to criticize. And in every aspect of judiciary also, no one can stop it. We will proceed with this act, and this is a beginning. We are blessed with the presence of Sri Prashant Bhushan ji. I honorably say that he has formed a new organization, India Deserves Better, like Yogendra Yadav, Madan B. Lokur. I also fortunately happened to be a representative from South India. So such a way of thinking is spreading all over our nation. So our minds are getting brown. Don't be afraid that our constitution will be surrendered at any point of time. Thank you.
Thank you, President. Now I request our Honorable District Judge S. Krishnakumar Sir to kindly inaugurate today's function.
The President of Calicut Bar Association, Mr. M.S. Saji, the distinguished guests of this day, Advocate Prashant Bhushan, other judicial officers, friends, ladies and gentlemen. Different persons have different views with respect to the challenges faced by Indian judiciary. That depends upon the person and his personality. My opinion is that. Suppose a common man is speaking about Indian judiciary, he might not think about such long words or worse words used by the advocate. The common man wants a judiciary which is imparting justice to him. That should be the view of a common man. So my view is that you should face this challenge, that is the Indian challenges faced by Indian judiciary in the view of a common man. Not to the upper class or super class, but as a common man, what is your challenge? With this short, I am not going to the other controversies which Mr. Saji has spoken. As an officer, I have got my own restrictions to speak about this function, and I speak about the subject under discussion. So, with your permission, I just inaugurate this function. Thank you all.
Thank you, sir. Now it is time to invite the chief guest of the day, Advocate Prashant Bhushan, to deliver the keynote address. Topic: the subject is the challenges faced by the Indian judiciary.
Respected judges on the dais present here, our members and office bearers of the Calicut Bar Association, all the lawyers present here, ladies and gentlemen. It's indeed a great pleasure for me to be invited at this series of lectures on the challenges faced by the Indian judiciary and to effectively deliver the first lecture on this subject. In order to understand the challenges faced by the judiciary, we first need to understand what is the role given to the judiciary by our Constitution. The Constitution created a democracy with and gave fundamental rights to citizens in order to effectuate that democracy, and it also established certain institutions like the Election Commission, Comptroller and Auditor General, Public Service Commission, various institutions, and the judiciary in order to ensure that democracy will function properly, in order to ensure that fundamental rights of citizens will be respected, in order to ensure that all institutions created by the Constitution perform their duty assigned to it by the Constitution. Because every power given to any institution, whether it is to the executive, to the police, or whether it is to the Election Commission, or whether it is to the Comptroller and Auditor General, every power is coupled with a duty. And every institution has a duty to exercise that power given to it when the need arises. And the most important institution created by the Constitution is the Indian judiciary, the higher judiciary, the high courts and the Supreme Court in particular. And the duty assigned to the higher judiciary is not merely to deliver justice, to dispense justice in ordinary disputes which come to the courts. That is, of course, a very important function of the judiciary. But the other important function, which sometimes we do not remember, is the duty to protect the fundamental rights of citizens, the duty to protect democracy, and the duty to ensure that all institutions perform the duty which has been given to them by the Constitution. Now today, what we see in the country, and that is why I feel that the challenges before the Indian judiciary today are more serious, far bigger than they have ever been before since the founding of our republic, is because today we see a specter in the country where fundamental rights, even without declaring an emergency, you see in 1975 an emergency was declared, fundamental rights were suspended officially. Supreme Court also said that habeas corpus is also not maintainable, nobody can challenge their illegal detention. Press censorship was imposed. But today what we are seeing in this country is a far more insidious form of emergency where there is no declared emergency, but the assault on fundamental rights, on democratic institutions, on democracy itself is far more serious than it was during the declared emergency of 1975. And I say this because on the one hand, you see, during the emergency, two things happened. Mainly, one was that people were being arrested, people who were perceived to be opposed, politically opposed to the government were arrested and put in jail. And the second thing was that press censorship was imposed. Today, even though there is no declared emergency, we are seeing the spectre of people who are just opposing the government. For example, 3 days ago, 5 people in UP were arrested for putting up posters saying that there is a lot of inflation, price rise, gas prices, petrol prices, rupees falling, etc. and they were put in prison. Yesterday, FIRs were registered against people, against Muslims who were offering namaz at a new mall that has been made in Lucknow. Muhammad Zubair, who runs a fact-checking website and who exposes falsehood being uttered by anybody, whether it is by the ruling party or the opposition party or anybody, he has been arrested for calling out hate mongers who are purveying hatred in society, communal hatred in society, for saying that this person is purveying hatred. Why isn't action being taken against him? He has been arrested, multiple FIRs, multiple arrests in different states, etc. And worst, what we are seeing is that the Supreme Court in a few cases recently, like in this Zakia Jafri case of Gujarat, or more recently, day before yesterday, in that Chhattisgarh killings case, has not only dismissed those petitions, but has virtually ordered that the petitioners be put in jail. 5 lakhs penalty has been imposed, petitioners have been put in jail, etc. So what we are seeing is an all-around assault on the liberty of citizens. Firstly, of course, minority community. We are seeing minority, especially Muslims in this country. Today, they are clearly seeing that they have been reduced to second-class citizens. Mobs can be let loose upon them on the streets. People can abuse them in television studios, abuse them on the social media, etc., and there is no action against those abusers or the hate mongers, etc. And anybody who dissents, anybody who questions the government runs the risk of being put in jail by charges of sedition, sometimes charges under UAPA, etc., being slapped upon them. So therefore, it's not a matter of how many people have been put in jail. During the emergency, about 1 lakh people had been arrested. Today, maybe 5,000 people have been arrested or 10,000 people have been arrested. But anybody who is seen as seriously opposing the government or questioning the government runs the risk today of being arrested, facing multiple charges in multiple states, etc., running from pillar to post, trying to get bail and rotting in jail for years on end without any trial. So the situation of civil liberties is no better than what it was during the emergency. So far as press censorship is concerned, even though there is no formal press censorship, informally what we are seeing is that journalists are being jailed for saying some things which are unpalatable to the government. What we are seeing is that the mainstream media, particularly the electronic media, has been reduced to becoming just cheerleaders and purveyors of propaganda of the government. So the large section of the mainstream media has collapsed, its independence has collapsed, and the independence has collapsed due to a variety of techniques employed. One is that you give government advertisements only to those people or those media which follow what you want to say, which become instruments of your propaganda. Second is, if they don't fall in line, even then, you use the enforcement agencies, Enforcement Directorate, Income Tax Department, CBI, etc., in order to bring them to heel. And sometimes even packets are being sent to these anchors and editors, etc. of these newspapers, direct packets. But more serious than that is the virtual collapse of the rule of law and the collapse of all institutions. There are mobs out on the streets in the name of either cow slaughter, in the name of love jihad, who can just go and beat up anybody that they want, and the police remains a helpless bystander, helpless or sometimes complicit bystander. And we are seeing this in many, many states, almost across the board. So, we are seeing a situation where people who speak against the government run the risk of being just abused and trolled on the social media. Abuses, threats of rape, murder, etc. are being meted out to them. I spoke about the media, that the media as an institution, its independence has collapsed to a very large extent. Of course, there is still the internet media or the social media which is standing up. But by and large, the mainstream media's independence has collapsed. It is not doing the job which it is supposed to do. But look at other institutions. Look at the Election Commission. Ever since Mr. Seshan became the Election Commissioner, the Election Commission was supposed to be a citadel of independence. But in the last 6-7 years, what we are seeing is that the Election Commission is only going after, for example, when there are violations of the Model Code of Conduct. Election Commission pursues only the opposition, does not pursue senior members of the ruling party for violating codes of conduct. Dates of elections are being announced by the Election Commission at the instance of the government. Sometimes the government or the ruling party announces the dates of the elections even before the Election Commission officially makes the announcement of dates according to their convenience. We have seen the Comptroller and Auditor General was one of the most independent institutions in India which used to do audit of all government departments and government funds, etc. In the last 7 years, audits of central government departments and central government institutions has been reduced by 75% by the CAG. For the first time since the CAG was formed, a defense audit did not have pricing details. Whenever the CAG does a defense audit of any defense deal, pricing details are always given in that audit. In the Rafale deal, for the first time, the pricing details were removed from the audit report, and this fact that pricing details would be removed from the audit report was known to the government even before the report was prepared, because the government stated this in a sealed cover to the Supreme Court even before the report was prepared, that in this audit the pricing details have been taken out. Police has become, you see, there was an important judgment given by the Supreme Court in Prakash Singh's case for police reforms, which was in line with the judgment on the CBI in Vineet Narayan's case, which was to essentially make the police independent of the government, of the political government. But today we are seeing that why just the police? The CBI, the Enforcement Directorate, not so much the CBI, but the Enforcement Directorate, the NIA, the Narcotics Control Bureau, they are just acting as instrumentalities of the political establishment in order to pursue whoever they feel whoever they feel should be pursued according to their political interests, and those who join the ruling party, they are not pursued. And we are seeing this across the board. Almost every investigating agency has been reduced to an instrumentality of the government, despite several decisions of the Supreme Court about what needs to be done in order to make the police independent. So we are seeing an assault on institutions, on our democracy across the board. You see, elections, in order to, firstly, we did not make what we call participatory democracy, we created a representative democracy. But even in that representative democracy, the parliamentary committees were an important instrument for giving some participation to the people in lawmaking. Laws which were placed before Parliament were referred to parliamentary committees where people would be invited, all the stakeholders would be invited to give their views on those laws. Today, the system of parliamentary committees has been virtually done away with. Virtually no law in the last 5 years has been referred to any parliamentary committee. Laws are being passed in Parliament in 2 minutes. 50 laws passed in 5 minutes without any discussion, without anybody knowing which laws have been passed. 50 laws are being passed as finance bills, which means that law will not even go for voting to the Raj Sabha. The ordinary constitution provides that every law has to be passed by both houses of parliament. But here what we are seeing is that Raj Sabha is being bypassed altogether and laws are being passed through money bills. Therefore, it is in this situation of our democracy, at this juncture of our country, that we have to see the role of the judiciary. Because the role of the judiciary is not merely to administer the law and decide disputes. It is also as much to preserve democracy, to preserve fundamental rights, and to ensure that other institutions perform their duty according to the law. And if we see, you see, there were endemic problems with the judiciary. There is a problem of lack of access, which has been a problem throughout, that ordinary people cannot access the judiciary because they need to go through lawyers, because the procedural laws are very complex. A law was brought to address this problem. It's called the Gram Nyayalaya Act. The idea was to set up Gram Nyayalayas at the sub-tehsil level, at the block level, where ordinary cases could be tried without all these procedural rules of CPC, CRPC, etc., where people could access those Gram Nyayalayas without the help of lawyers. Unfortunately, those Gram Nyayalayas have not been actualized, with the result that the majority of the people cannot even access the judiciary. This is the first challenge, and that challenge has been there for a very long time. The second problem is delays. Even when cases are filed, cases keep pending for years altogether. People keep getting dates. Of course, in Kerala, I understand this situation is better, but in many other states, cases linger on for decades altogether. Even thereafter, when they come to be decided, they are often wrongly decided because of lack of competence of the judge, and sometimes because of lack of integrity of the judges. So these are endemic problems that have been plaguing the judiciary. These are endemic challenges before the Indian judiciary. That is access, delays, quality, and integrity. And for that, we know what needs to be done. For example, for access, we know that you need to set up these informal courts like Gram Nyayalayas for ordinary cases. For delays, we know that we need to increase the strength of the judiciary. We need to improve the quality of our judges. So we need to improve the method of selection of judges, to improve the quality of judges. We need to have a much more credible system of selecting judges than exists at present. And the last is that we need to have some method of holding judges accountable. Today, under the Constitution, for the High Court judges and the Supreme Court, of course the lower judiciary is accountable to the High Court. But the High Court is not accountable to anybody. The Supreme Court is not accountable to anybody, judges are not accountable to anybody. The only action that can be taken against them is impeachment or transfer, that's all. Impeachment or transfer. There is no independent institution which has been created to examine complaints, because impeachment cannot be initiated by ordinary people. Impeachment can only be initiated by 100 MPs of the Lok Sabha or 50 MPs of the Raj Sabha. For ordinary people, there is no mechanism, there is no institution where they can complain about misconduct of judges of the High Court or the Supreme Court. For a long time we have been saying that at least we need two kinds of institutions. One is an appointments commission, not the Judicial Appointments Commission bill which the government had brought, because there the law minister was there, then 3 Supreme Court judges were there ex officio. You see, ex officio people cannot devote adequate time to the business of selecting judges, which is a serious business, it's a full-time business. If you need to have a proper institution for selecting judges, it has to be a full-time body. In England, there is a Judicial Appointments Commission or a body to appoint. It's a full-time body of 15 people. We need to have a full-time body which can properly go through, make a criteria for selecting judges. Thereafter, evaluate all the possible people, all the possible contenders on the basis of that criteria and do it in a credible manner. And thereafter, select those judges, and it should all be done with some degree of transparency so that the common people know who are the people under consideration, who are the people who have been shortlisted, so that if they have any information, good or bad, about those judges who have been shortlisted, they can send that information to the selecting committee. So, unfortunately, that has also not been done. These are, of course, endemic problems which have plagued our judiciary for a long time, and these are endemic challenges before our judiciary. But there is a fresh challenge that we are seeing today. And that challenge is the challenge of independence of the judiciary. You see, first, when the Constitution was made, the Constitution guaranteed independence of the higher judiciary by making removal of judges of the High Court and the Supreme Court very difficult through a process of impeachment. And of course, impeachment is not the ideal way of holding judges accountable, because that's a political process. It starts with political parties and it ends also in Parliament. So, but that was at that time the only thing which was created. And it was thought that making it very difficult to remove judges, that the government cannot by itself remove judges, would make the judges quite independent of the government, because independence was necessary because of their second job, or rather their primary job, which was to hold the government to account, to ensure that fundamental rights are protected, to ensure that other institutions perform their job. Now, what we are seeing today, and what we have seen in the last 5-6 years, is a gradual erosion of the independence of the judiciary. And this erosion is taking place in many ways. Of course, one way was existing even earlier. That was the lure of post-retirement jobs. This was there for a very long time. This problem has been there for a very long time, that judges, as Arun Jaitley said in a speech in Parliament, that the lure of post-retirement jobs influences pre-retirement judgments of these judges. And that fact has been there for a very long time, because unfortunately various governments across the years have been using this instrument of the lure of post-retirement jobs in order to compromise the independence of sitting judges. The other problem was the government's role in appointing judges. Now this was there initially, that government had the primary role in appointing judges. Thereafter, after the second judge's case, this role, the primary role of selecting judges, was taken over by the collegium of the Supreme Court itself. They said that the collegium of 5 senior most judges, 3 or 5 senior most judges, will decide as to who is to be selected, who is to be recommended. After that, we felt that government interference in selecting judges would end. But unfortunately, this present government has adopted a new system for even making a mockery of the collegium selecting judges. What is happening now is, when the collegium makes a recommendation, I know because I have been dealing with many of these cases, we have several petitions pending in the Supreme Court about this also. When the collegium makes a recommendation, let's say of 10 judges, government likes only 3 of them. They will issue a notification regarding those 3 and keep the other names pending. Sometimes the government keeps those names pending even for several years altogether. Then when the Chief Justices follow it up with the government, eventually the government, after 1 or 2 or 3 years, sends the recommendation back that these names are not acceptable to us. Then the law says that if the collegium unanimously reiterates those names, then the government has no option but to issue the notification for their appointment. But what we are seeing is, and there are dozens of cases of this kind, that even when the collegium has unanimously reiterated names, notifications are not being issued, sometimes for years altogether. Now, in these circumstances, of course, the judiciary or the Supreme Court can issue a mandamus to the government, and on threat of contempt, that look, if you do not issue the notification within 1 week, we will hold the law minister or the law secretary accountable and send him to jail. If this threat was used, then I believe that most of these unanimously rated recommendations would get appointed. But unfortunately, that threat is not being used. And now I come to a new, very disturbing method of course, I mentioned 2 problems about how the government is able to get around this independence of the judiciary: post-retirement jobs and interfering with appointments. This new method which has now been used is, if the government uses all the agencies at its disposal, the IB, the ED, the CBI, every agency, in order to what they call make a dossier on the judge. If they find any weakness, so every judge has a dossier, government has a dossier on every judge. In that dossier, if they find any weakness of that judge, for example, somebody has indulged in sexual harassment, or somebody is involved in a CBI case, like one of the previous Chief Justices was involved in that medical college scam. If they find anything by which can be used to influence that judge, then that is used to influence that judge. And if he happens to be the Chief Justice, then, and if you are able to somehow influence the Chief Justice of the Supreme Court, then half the judiciary is under your control. Because the Chief Justice, unfortunately, I say this I use this word unfortunately because I feel that this power of master of roster given to the Chief Justice, it has not been given, it's a convention, and it's a totally undemocratic and wrong convention, that the Chief Justice alone decides which case will be heard by which bench. For example, that Birla Sahara case involving corruption of the Prime Minister was sent to the number 12 judge. There is no justification of picking up Justice Arun Mishra, who was at that time the number 12 judge, and asking him to deal with that case. Thereafter, the Judge Loya case was also sent to Arun Mishra, which led to that unprecedented press conference of 4 of the senior-most judges of the Supreme Court, who said in that press conference that because of the misuse of the power of Master of Roster by the then Chief Justice, democracy is in danger. Because all politically sensitive cases can then be sent to the judge who will decide in favor of the government. And this has been happening. This has been happening. This is what those 4 judges said in that press conference. And therefore I say that giving this power of Master of Roster to just one person is a totally undemocratic, and in my view, it's a wrong practice. We had gone to the Supreme Court with a petition saying that this power should be exercised by the collegium of the 5 senior-most judges, who must make the roster together and not just by the Chief Justice alone. Unfortunately, they dismissed that petition. So, this is another challenge before our judiciary because, and as I say, that this is today the most serious challenge faced by our judiciary, that is the lack of independence or the growing lack of independence of the higher judiciary. Of course, one thing which always happened during the emergency also, that when there is a very powerful executive, as there was at that time, and there was fear, there was certainly fear that that even judges may be arrested. And therefore, many judges at that time just crumbled with that fear. They lacked the spine to stand up to that pressure and that fear. Today, the kind of government that we have at the center, which is kind of seen as all-powerful, crushing all institutions, etc., there also I feel that it is the fear factor which is also operating to gradually reduce the independence of the higher judiciary. So in my view, this is today one of the most serious challenges before the Indian judiciary as to how to ensure that the judiciary remains independent. One of the things, so the question is, what should we do as aware citizens, as concerned citizens, as engaged citizens? And lawyers have a particular responsibility in this kind of situation. So the first thing that I think every citizen, and in particular every lawyer, needs to do is to comment boldly and fearlessly about the actions of the judiciary without having any fear of contempt. I think the time has come for us to shed this fear of contempt. In my view, we have challenged this scandalization of court and interference and lowering the dignity of court. I have challenged that section of the Contempt of Courts Act. That challenge is pending before the Karnataka High Court. Arun Shori, Mr. N. Ram, one more former editor of Outlook, and I have together challenged that provision, saying that this is unconstitutional because their judges sit in their own cause, etc., and this should be done away with. There is no justification for this. You see, contempt has 3 parts. Civil contempt, that is perfectly fine, violating any order of the court, should be punished. Second, criminal contempt has 2 parts. Interfering with the administration of justice. If you threaten some judge, you threaten a witness, you threaten a lawyer, or you do not allow court proceedings to go on, that is interference with the administration of justice, that should be punished. But the third part, which is scandalizing the court or lowering the authority of the court, this part, to our mind, this has been done away with in most civilized countries. It's still there in India. It's an anachronism, but it is still there in India, and it is being used in order to silence criticism of the judiciary. And therefore it is our duty to, especially the duty of lawyers, to boldly say what we feel about the actions of the judiciary. Not abuse. Of course there should not be any abuse, etc. But we should say what we really feel. If we feel, I was watching a YouTube video today, one person called Naveen Kumar who does this Article 19 about this recent judgment of the Supreme Court in this Chhattisgarh tribal killings case, where 5 lakhs penalty has been imposed and virtually, the petitioner has been indicted for approaching the court. That person does a very bold video. Of course, he does it in a sort of sarcastic manner, but he does a very bold video exposing the ridiculousness of what the Supreme Court has done. So we need to, firstly, we need to praise them when they do the right thing. I always do that. I always praise any good judgment coming out of the Supreme Court. And I always criticize any really bad judgment coming out of the Supreme Court. And you have to criticize it with reasons. You have to, and if you do it collectively, it is more effective. If lawyers together get together and issue a collective statement about a really terrible judgment or about a really good judgment, praising the judiciary for that, that really encourages judges to do the right thing, to perform their duty according to the Constitution. So this is one of the important things that we need to do. The second thing is to campaign for judicial reforms. You see, we need many reforms. We need to effectuate Gram Nyayalayas and ensure that they function in an informal manner where people can access the courts without lawyers. We need to ensure that number of judges and the number of courts is increased, which the Law Commission has been recommending for a very long time. We need to ensure that there is a proper full-time judicial appointments commission and a proper system and transparent system of selecting judges. And we need to have a judicial accountability commission where people can make complaints about misconduct of judges, and that commission should have the power to investigate that and thereafter take action against judges. Now these are reforms, and we need to campaign for abolishing this master of roster system. These are reforms which are required, but they are not being done. Everybody knows that they are required. Everybody knows for the last 50 years that these are required. But neither the government is doing anything, nor the judiciary is doing anything to effectuate these reforms because they feel that there is no public pressure. These reforms will happen only if there is public pressure, if there is a public campaign for these reforms. And that campaign has to be spearheaded by lawyers, because only lawyers and retired judges know what is wrong with the system. They know what is happening within the system, and therefore they need to be on the forefront and at the spearhead of this campaign for judicial reforms. And I hope that each one of you will take these tasks that I have mentioned seriously and do them. I am sure that you will. Thank you very much.
Thank you, sir. Now, as a token of love and respect, I request the President of Calicut Bar Association, Advocate M.S. Saji, to hand over momentum to the Chief Guest. Thank you, sir. Now, to facilitate this function, I request the Honorable Vigilance Judge, Sri T. Madhusudan, to address the gathering.
Honorable Principal Judge Sri Krishna Kumar sir, President of the meeting, Advocate Saji, energetic President of the Calicut Bar Association, Advocate Sri Prashant Bhushan, renowned lawyer, public activist, senior district judges, my colleagues, distinguished guests on the dais and off the dais, senior advocates and friends. I am standing here with an immense pleasure as I am given an opportunity to speak on the inauguration of a debate series on a great subject. I express my deep sense of gratitude to the organizers of this function at first. As we all know, our country is the world's largest democratic country which functions based on a written constitution. Though there are three pillars, legislature, executive and judiciary, the Indian judiciary acts as the guardian of the Constitution of India and protects the fundamental rights of citizens. Thus, needless to say that judiciary is the most important organ of the citizens of India. So, any challenge to the judiciary and justice delivery system will certainly adversely affect the independence, democracy and unity of our nation. So, it is the duty of every citizen to ensure rule of law and defend any sort of challenge against the judicial system in general. As my district judge said, I will pursue the challenges faced by the judiciary in the pursuit of a common man. Main challenges faced by judiciary are in the eye of a common man is delay in justice, huge backlogs, and low judges' strength, etc. When we are talking about the delay and backlogs of cases, the finger will be first pointing towards the judges. But according to me, there is no meaning in such an accusation. My experience as a lawyer and later as a judge prompts me to say that judges alone are not responsible for the delay in justice delivery system and pendency of cases. According to me, lack of infrastructure, low strength of judges, and lack of sufficient number of courts are the main reasons for the delay. I am not saying that establishment of more courts is the only way out. Establishment of more courts also will not save the situation unless there are good number of efficient lawyers. Seeking unnecessary adjournments is also another situation for lack of another situation or delay in disposal of cases. In that sense, to a certain extent, lawyers are also responsible for the delay in justice delivery. In this connection, I would like to say that all the more necessary is an erudite bar which could enlighten the judges. It goes without saying that role of bar association is important one in this regard. Lack of infrastructure and less use of technology are also reasons for the delay. Fortunately, now we have an era of disposal of cases using technological advancements, overcoming some resistance from the side of some stakeholders. I would like to add that for free and fair delivery of justice and to have a strong independent judiciary, fair, honest and erudite judges and lawyers alone are not sufficient. That should be measures to improve the working conditions of the stakeholders. Unless good working conditions are ensured to the stakeholders, productivity cannot be legitimately expected from them. For that, there should be a good bar and bench relationship. Role of bar associations is unlimited in this regard. Needless to say that bar associations have an important role in maintaining healthy, productive and good bar and bench relationship. So at any rate, subject of debate series is an important one in the present day context. A strong, independent, honest and transparent judiciary from the bottom to the top is a must for a healthy democratic country. We cannot lose sight of the fact that an effective justice delivery system is the need of the hour. The members of the fraternity should be in the forefront to protect the rule of law and system in general. And I'm not going deep into the subject as the eminent speaker, as other other challenges faced by the judiciary. As we know, the main area of our speaker was his interest in human rights, environmental protection and accountability of public servants is known to all. He has taken up about 500 cases dealing with good causes on pro bono basis. So needless to say that organizers of this debate series have chosen an apt person to lead the first session. I wish organizers could bring similar eminent personalities, and I expect brainstorming sessions in this debate series. I wish all success and best wishes to the debate series, apart from wishing success to all the future endeavors of Calicut Bar Association. Once again, I extend my sincere thanks and gratitude for giving me an opportunity. Jai Hind.
Thank you very much, sir. Now I request our district government leader, Advocate K.N. Jayakumar, to facilitate this program.
Respected President of this function, Mr. Saji, President of Calicut Bar Association, distinguished guest, Senior Advocate, Supreme Court of India, Sri Prashant Bhushan, our beloved District Judge, Mr. C. Krishna Kumar, and other judges on and off the dais, senior lawyers, and my dear friends. There is no scope for a felicitation here because the eminent speaker, our chief guest, has very elaborately spoken regarding the subject. So I am not going to that subject. Regarding the independence of judiciary, we have heard from the mouth of the guest. There are different challenges. We have very elaborately spoke regarding the challenges faced by the Indian judiciary. This was discussed for a long time, but still that continues to be so. That is very unfortunate. So from the speech, and we all know that democratization of judiciary is the main thing which we urge. That is not being done because the judges are appointed by the judges. That is the main thing. And the other challenge by my chief guest is delay. That's everybody knows that delay in disposing or delaying the justice delivery system. Because we all know that there was a case pronounced by Supreme Court in the year 1996, common cause case, common cause judgment. That was against the delaying of judicial proceedings. In that judgment, it was one case should be disposed in there like that in each and every case, 138 case, etc. After 1 year, the accused will be discharged in such cases. But that most important thing is that petition was filed in 1980 or so. It took 14 or 15 years to pronounce a judgment in that common cause case regarding disposal of cases earlier, at the earliest. So that is the situation that's prevailing here now, the present scenario. So every time there is hue and cry regarding the independence of judiciary and democratization of judiciary, but still it continues the same. So that situation has to be changed. That's my opinion. I'm not going to elaborate on the streets. That is to be changed. the one most important thing which our eminent speaker, our chief guest has put forward before us is we have to take the challenge. We have to be in the forefront of this challenge. So somebody should take this challenge and agitate. So otherwise, because that is the difficulty, because no political parties, nobody is behind this, because our district judge and vigilance judge has said that it should be viewed in the view of a common man, because common man cannot do in this case. Common man, the last, at present, for the present scenario, the last resort of the common man is judiciary. They believe that. But they won't agitate against that. They won't see that. It is for the lawyers and those who are working in this system. They will know the difficulty of this justice delivery system and the challenges faced by the justice delivery system. So we have to take it up. We must be in the forefront. Anyway, I'm not going to the subject elaborately. First of all, I congratulate the Bar Association for taking up this subject, very most relevant subject, and bringing the most eminent personalities in this regard. And I also thank Bar Association office bearers for giving me an opportunity to be present and speak on this one. Thank you very much.
Thank you, sir. Now it's time for vote of thanks. I request the Treasurer of Calicut Bar Association, Advocate K.V. Jyoti Prasad.
President of the Calicut Bar Association, Sri M.S. Saji, our Honorable District and Sessions Judge, S. Krishnakumar sir, Chief Guest of the Day, VIP Dignitary, Supreme Court Lawyer, Prashant Bhushan sir, our dear Secretary Srikanth, Vigilance Judge T. Madhusudanan sir, Government Pleader K.N. Jayakumar sir, and my dear friends in the audience. I have been privileged to extend a vote of thanks to the participants of this memorable debate series. If I propose a brief vote of thanks to our esteemed chief guest, I will not be able to touch his credentials or qualities. Therefore, I propose a profound vote of thanks to our respected chief guest. Thank you, sir. The presence of district judge and other judicial officers is inspiring us. I thank on behalf of committee, I thank him on behalf of committee and myself. Thank you, sir. Our men in media deserve a special thanks for encouragement and their participation. Thank you. As a formality, I thank our President M.S. Saji and Secretary Srikanth for conducting such a beautiful event. No function will be successful without a cooperative audience. I thank all the participants in the audience. Thank you all once again.
Thank you. With this, we are concluding this session. Please stand up for national anthem.
Punjab, Sindh, Gujarat, Maratha, Dravida, Utkala, Vanga, Vindhya, Himachala, Yamuna, Ganga, Uchala, Jaladhi, Taranga. तव शुभ नामे जागे, तव शुभ आशीष मागे, गाहे तव जय गाथा, जन गण मंगलदायक जय हे भारत।